Okay, welcome to Preventing Sexual Harassment and Discrimination Training for Leaders. We have specifically customized this training for nonprofit organizations attending today. Many of you are board members, executive directors, and people leaders. Again, welcome. Next. So my name is Sandra Lopera, and I will be one of your facilitators today. I'm an experienced HR professional and very experienced in managing workplace harassment policies, education, and complaints. Before we get started, I'd like to introduce you to the rest of the eGauge team. My co-facilitator, who is on camera today, is Michael Kreitman, and he is an employment and labor attorney who's been practicing for over 25 years, representing management in all aspects of employment law. We also have two additional consultants managing administration today. Tracy Aparo is a 30-year HR veteran with vast experience in this topic. Many of you know her. And Jake Aparo is attending Edinburgh University pursuing his master's in business management. They'll be monitoring the chat for us today for responses and questions and help us with all administrative needs. So today we're going to be covering the following. We're going to be discussing the law regarding discrimination and harassment in the workplace, as well as any reasonable accommodations for persons with disability or sincerely held religious beliefs and practices. We'll also be covering the responsibilities that you as leaders have under the law and your legal obligations when you have to act, and best practices for leaders to help shepherd a culture of respect. Next. Just a few housekeeping items before we get started. As you may have seen in the first slide, we are recording this session. So thank you for allowing that to happen. We're going to do that for future use and training. Your camera and audio has been turned off just so we can focus on slides. You'll be able to communicate with us through chat function. So ask questions, and we will try to get to those questions as soon as possible. Just so you all know, we will also send a summary of questions and answers at the end along with the presentation. This will have interactive scenarios. So Mike will be posting some questions, and we want you to respond via chat, or if you'd like, write it on a piece of paper, but we want you to think about and try to absorb some of what is being taught here. And halfway through the presentation, we'll provide a 10-minute break. Next. So today, following today's session, you should take away with you and understand state and federal laws on sexual harassment and discrimination and your roles and responsibilities around that. You should be able to identify the conduct that constitutes sexual harassment and discrimination. You will know what it means to be on notice of sexual harassment. Just when you are on notice, it is your obligation to immediately investigate and take steps towards appropriate corrective action. We will give you some tips on preventative measures that you must take as a leader to prevent sexual harassment and discrimination in your workplace, and help you understand your role in stopping problematic conduct. Next. So next, we're going to talk about your role and legal requirements attached with your role as organization leaders. So first, we'll speak to board members and executive directors. As board members and executive directors, I know that you most likely have extensive experience and training in these areas. We recognize that. And we also recognize that you may not always have daily interaction with staff members, but you do play a critical role by setting expectations around culture in your workplace and behaviors and expected behaviors. So in our experience, the following are key factors, focus areas in which will help you build culture and mitigate risk. First of all, we commend you as leaders for joining today's training. We recommend that you ensure that all new staff go through this training in the future, as well as repeat it, on an annual basis. So having an effective internal complaint procedure in place and making employees aware of it is key. So we recommend that all employees know how to raise concerns and file a complaint so issues get addressed on a timely fashion. Very important to role model professional behavior every chance that you get. We know that it starts at the top. So we recommend that your organizations have a code of conduct if you don't already have one, or similar policies in place. This will help define the organization's culture and establish a standard or North Star that is aspired to. And lastly, communicate. We all know that that we want the staff to know that there's a code of conduct and anti-harassment policy. So this gets done through emails, notices, and meetings. For the rest of the leaders on the call, you have a big role in culture of your organizations. You can either make it great or you can influence it in a negative way. So employees, I just want to let you know that employers are automatically liable for harassment by a supervisor or leader that results in negative employment actions such as terminations, failure to promote or hire, or loss of wages. If a supervisor's harassment results in a hostile work environment, which my co-facilitator Mike will define shortly, the employer can avoid liability only if they prove that you as an employer took reasonable steps to prevent and promptly correct the harassing behavior, or the employee reasonably failed to take advantage of any preventative actions or corrective actions that you provided as an employer. Also want to let you know that employers are liable for non-supervisory employees or maybe contractors that are under their control if they knew or should have known about harassment that was taking place and failed to take prompt and appropriate corrective action. So we have a few suggestions which are on this slide. Obviously, lead by example, model behavior, promote your culture of inclusion and engagement, know and understand and comply with the laws. Very important to report suspected violations to your leadership team and act when you are on notice, when somebody's put you on notice of any behaviors that are concerning, and empower your employees to raise concerns without fear of retaliation, and communicate your commitment to acting legally and ethically. Okay, and so to best prevent harassment and discrimination, every level in the organization has a role to play and must understand cultural expectations. We at eGauge will be completing a training for your employees next week, and we'll provide a video training for volunteers. We need your help in ensuring that your staff registers for this training next week, so please encourage them to register. There's still time. And for volunteer training, it will be from a viewpoint of the cultural expectations that you have of them. Next. So next, Mike will help us define and understand discrimination. So over to you, Mike. Mike, you're on mute.
I'm sorry, I'm on mute. Great lead up on the important topic. So thank you. So, as leaders, you need to know the laws that govern the workplace, and you have to be able to recognize or spot problematic conduct. So we're going to talk about that for a while. What is discrimination? What is harassment? And then we're going to discuss your obligations and the organization's obligations, once you've identified that this conduct is taking place in the workplace. So let's do a little bit of exercise. How can discrimination occur in the workplace? What kind of conduct constitutes harassment or discrimination? Take 30 seconds if you want to self-answer on a piece of paper, or put some of your put your answers on the chat. How does discrimination arise in the workplace? And I'm going to be monitoring the chat. Okay, let's go into the definition then, in terms of what is this discrimination. And the EEOC, Equal Employment Opportunity Commission, it's a federal agency that handles discrimination complaints and also creates rules and regulations that interpret the federal discrimination laws. And the EEOC defines discrimination as treating a person differently or less favorably, and sets out 5 different categories of discrimination. Now, we're going to go into detail on each one, but let me just kind of tick off each of these categories now. Number 1, unfair treatment because of race or color or religion. And there's a number of factors the law refers to as protected characteristics, but treating someone adversely or differently because of these characteristics. Another type of discrimination, harassment by a manager, coworker, a third party, because of race or color, these protected characteristics. A third type of discrimination in the workplace is not providing a reasonable accommodation or a workplace change that the employee needs because of his or her religious beliefs or disabilities. And we'll talk today about your obligations to make workplace modifications. Retaliation. Recall, this is when an employee could assert his or her legal rights, complain about job discrimination, or assist with a discrimination investigation, and adverse action is taken against that employee. And finally, the EEOC identifies this last type, called improper questions about or disclosure of genetic or medical information or protected characteristics. We're going to discuss all of these today, but again, I wanted you to know how the federal agency defines discrimination. Okay, next slide. Interesting statistic. Employees can file a charge of discrimination with the EEOC. This chart shows filings in 2020. Keep in mind that each charge that an employee files could have multiple claims. An employee can claim discrimination based on race or age, and can also claim retaliation. The greatest number of charges were based on retaliation claims. After that, we had disability, then race, then sex, and then age. The numbers and the allocations haven't significantly changed since 2020. and we'll discuss the EEOC process in greater detail. But once a charge is filed, the organization has to investigate and respond to it. So, this is real stuff. And I want you to park this first category you see, retaliation, because we're gonna talk about that later. But when you see that it's the biggest category of claims filed, so important to be aware of what it is and how to avoid that kind of claim. All right, next. So the laws that we're going to be talking about today, you need to be familiar with them. I'm sure you've heard them before. There should be a quick refresher. Title VII of the Civil Rights Act of 1964 covers age, gender, national origin, ancestry, religious discrimination. The ADA, Americans with Disabilities Act, prohibits discrimination based on a disability. You have the ADEA, which prohibits age discrimination and protects persons over 40 years of age from discrimination. And there is a state law called the Massachusetts Law Against Discrimination. This is the law in the state in which you're operating. And the MLAD, it's called, that law encompasses all of these different areas: race, gender, disability, age, etc. A charge of discrimination can be filed with the EEOC, as I mentioned, as well as with the Massachusetts Commission Against Discrimination. So an employee can file either charges in a federal forum or a state forum. And finally, you could have an employer could face federal or state court litigation alleging discrimination. And what we're hoping is that as a result of this training, you'll be able to avoid charges and lawsuits by ensuring that we have the right workplace culture and environment in place, and that you handle workplace concerns promptly, timely, the right way, and things don't get to the MCAD, the EEOC, or the litigation. Okay, next slide. The law is always changing. And recently in your state in Massachusetts, the Crown Act was passed just a few months back. And this prohibits discrimination based on hairstyles associated with race. Here's the definition of it. The key takeaway for you as leaders is you need to stay on top of legal developments. Here we have a new form of discrimination that's been created by the legislature. You need to be able to spot it. So, for example, I had a case very recently where the employee alleged that a manager said to her, and the employee was a Black employee, and the manager said, I think you would look better with straight hair, and you should wear your hair straight. And the employee alleged that violated that state's Crown Act. I had another case where the employee claimed that he was asked to remove his dreadlocks as a condition of continuing employment. Again, the claim is that it violates the state's Crown Act. So you just need to be aware, stay abreast of legal developments, because the law is constantly changing when it comes to the workplace. Okay, next. The EEOC in 2022, we covered over $500 million in monetary benefits for victims of discrimination. Again, the point here is that the claims are real, and a claim could well lead to liability. All right, so let's talk a few situations then. Let's jump right into some scenarios. How do employers get into trouble, and when could and how do these charges of discrimination arise? Well, here's one example. Employer doesn't hire a female applicant because she is pregnant. Is that discrimination? Well, what are some relevant issues? Was the female applicant qualified for the job? Was there a more qualified applicant? Or did the hiring manager think that this applicant might need a leave of absence after being hired? Or perhaps the hiring manager assumed that this applicant would be busy with childcare issues. Could be discrimination, depends on a number of factors. How about this one? Not promoting an employee because they cannot work on Sunday due to a religious accommodation. Is that discrimination? Well, let me suggest this. Let's say the employee just asked and was granted this Sunday accommodation. And then a few months later, they're passed over for a promotion. Was the failure to promote due to the request for the accommodation? Was there somebody more qualified for the position? Or was this person not ready to be promoted yet? How about this? Asking an employee when they plan to retire. Discrimination? Perhaps there's a friendly conversation that two colleagues or two employees are having about the benefits of retiring to Maine versus Florida. And it's not really discrimination. Or perhaps this question's being asked because the person asking it presumes that the other person is too old to perform the job and or should think about leaving soon. And maybe there's a younger person waiting in the wings for the job. So could be discrimination. Finally, not allowing an employee to wear a hijab to work. Is that discrimination? Well, if you work in a warehouse, perhaps there are safety concerns with wearing of the hijab if there's an assembly line or a conveyor belt, and it could cause workplace injury. Or is this anti-Muslim bias that I don't want you to wear that attire associated with your religion? Could be, don't know. But here's the best practice. Here's an important takeaway for everyone here. You should have documents for the employment decisions that you make. Certainly employment decisions regarding promotion, hiring, termination should be reviewed by a team of people to make sure the decisions are free from any kind of individual bias. And the importance of making a partner with a third party, an HR specialist, an attorney perhaps, in order to make sure that you were making decisions for the right reasons. But some examples of some sticky situations that you may have to deal with. All right, next slide. I call this the one of the most important slides of our session and probably the golden rule. The best way to avoid discrimination claims and to have a good workplace culture is to make employment decisions for legitimate business reasons. Generally, these are related to how the person performs the job or the qualifications and skills that the person brings to the table. All right, what are some of these situations? Well, hiring situation. What's relevant when you're hiring? The person's skills, previous experience, how he or she did on the interview, education, perhaps, if the job requires a certain degree. I recall a case where a person was not hired. Hiring manager felt that the applicant would not get along with the customers, with the organization's customers and clients. And the applicant was diverse. And the hiring manager said, our customers and clients are not as diverse, are not diverse. And I think we have a customer preference issue. Well, customer preference really is not a legitimate business reason for not hiring someone. How about when you're promoting, when you're considering a promotion or a salary increase? What's relevant to that? Well, how is the person doing in the current job? Is the person ready for more responsibilities? Have they had more responsibilities? And if so, how has the person performed? If it's a managerial position, how are the interpersonal skills? If you're doing a salary increase, are you following salary guidelines? Maybe it's 3% across the board. Maybe it's we're going to tie salary increases to certain quantifiable metrics that we have. So those would all be legitimate business reasons. But where you get into problems, say, is if you have a salary increase that is very arbitrary and really not tied to anything, not tied to some quantifiable metrics, not tied to a standard across the board increase. I think a good best practice, as I mentioned earlier, is reviewing your promotion and salary increase decisions by a team and not having it all concentrated in one person. Termination, a lot of EEOC claims arise out of termination decision. And, legitimate business reason for terminating, someone's not meeting performance expectations. Someone has engaged in misconduct, theft, or dishonesty, or another violation of company policy. And hopefully we have good documentation of these behaviors to support the termination. But those would all be legitimate business reasons. Let me give you a quick example of a case that I just handled that really shed some light on this issue when it comes to termination. I had a case where an employee was terminated for poor performance. President of the organization said that the person had interpersonal and managerial skills that were subpar. However, there was no documentation of any of these problems. There was no evidence of complaints by coworkers or observations by the manager, the president, of these interpersonal problems. And there was no documentation or evidence that the manager ever spoke to the employee about these interpersonal problems. And there were no performance reviews. Now, I'll add another fact to this for you. The employee had recently requested a work from home accommodation due to a medical condition. Now, the employee claimed in the lawsuit that the reason given for my termination was poor performance. And the employee said, it's not true. I was never told my performance was poor. I think the reason why I was terminated is because I asked for the accommodation. Now, what do we have here? Well, the performance may well have been poor, but it's going to be very difficult to prove that because we have no documentation. That's the best case scenario. The worst case is that, in fact, the person asked for an accommodation and the president terminated this person due to requesting that accommodation to which the person was legally entitled to. Long story short, best practices for those leaders on the call. The importance of internal review of decision-making to make sure you have documentation of performance problems or reasons for promotions or hiring decisions, to make sure you give employees feedback if he or she is not performing well, making the employee aware of performance problems through coaching. All best practices for leaders, for management, and things that, an HR expert, a third party can help you put in these best practices if you don't have them now. Okay, next slide. So What you can't make a employment decision on is what the law calls protected characteristics. Illegal, cannot do it. And there's many protected characteristics recognized by the law. I just talked about the Crown Act, for example, and hairstyle, but you have gender identity, sexual orientation, national origin, and we're going to send you the deck after the presentation, and you'll have this to refer to. But these are individual characteristics upon which the employer cannot make an employment decision. Okay, next slide. Okay, so some examples of what's going to be illegal decision-making. Not hiring a Muslim applicant because our employees and customers could claim that they are afraid of them. And I had a number of these claims after the 9/11 incident in New York City. Is that a legitimate business reason? No. How about this? Not promoting a female employee over a similarly qualified male employee because you think the female employee will need more time to take care of her children. Legitimate business reason? Note, key term here. They're similarly situated, equally qualified. And you pick the male employee because you think the female employee might have childcare problems. Not good. Here's one, assigning more clerical or administrative work to Black employees while assigning more substantive, complex work, let's call it, to Asian, white, or Hispanic employees. And all these employees have the same job title, same job description, they're in the same job. Looks like there's better tasks and better work given to the non-Black employees. And what are the trends here? What stands out? What is common among these fact patterns? Well, one, some stereotypical considerations. Female employees needing perhaps needing more time for childcare. Thinking that customers might react negatively to a certain type of employee in the Muslim applicant example. Number two, decisions that are not based on performance, but instead not based on qualifications or the ability to do the job, but instead on protected characteristics. So the best practice tip here that we can offer is to avoid the stereotypical thinking and decision based on perceived differences. As a leader, perhaps recognize any implicit bias you may bring to the decision-making process, and keep the reasons for a decision related to job performance, expectations, etc. Next slide.
Mike, before you move on, there's one good question that Jake pointed out that you may want to answer, and it is, what if your organization serves one protected class, such as women, and you want to have staff that supports the focus of that organization or mission, i.e. women? How would you recommend they go about that when they hire their employees?
That's a great question. First of all, I would recommend you consult with, be it an attorney or an HR expert. What you want to avoid is walking into what I'll call a reverse discrimination claim, where if you only hire women because you believe that's consistent with the mission of your organization, and you get a complaint by a male employee claiming it's reverse discrimination. Again, we don't see many of those, but you don't want to walk into that. It may well be that women in certain roles here is what we call a bona fide occupational qualification, a BFOQ. But again, we would have to have evidence to support that. Question to ask yourself is, could a male employee do the job effectively? I don't know. It's going to be a fact-specific analysis. There's organizations that serve protected classes. There might be organizations that focus on underserved children in certain areas. Could you have a policy that says we're only going to hire people from underserved communities or whose race matches the race of those in the community? Well, I think that could get you into trouble, because I think you'd be hard pressed to say, well, you mean someone who's of a different race couldn't handle that job effectively? So it's a good question. There's not an easy answer. And I go back, I would say, don't confuse the mission of the organization with who can do who's best qualified to do a job in the organization. So the answer is maybe. And I know that's not always the best answer, but we'd have to dig a lot more into this to determine if there really is a bona fide occupational qualification defense, should there be some kind of reverse discrimination claim. Listen, these issues are tough, workplace discrimination issues. And I think the best practice is really always to get advice from a third party to talk them out on the front end rather than deal with a claim on the back end. Okay, let's talk about retaliation. Recall that earlier slide that said retaliation is the largest percent of claims filed with the EEOC. So these are things that you want to avoid, but certainly they're very prevalent. The law, state and federal law, and your policies should all prohibit adverse employment action against an employee who engaged in what the law calls protected activity. What is that? Well, if you complain of harassment or discrimination, like you file an internal complaint, or you asserted your legal rights. For example, you asked for an accommodation for your disability. You complained that, or you raised a concern that you felt you were denied a promotion because of your race. That's protected activity. If you participate in an investigation, or if you, as I said, file a charge of discrimination. If you engage in that, you're protected against adverse action. Now, what might the adverse action be? It could be, it's a negative employment action, but it comes in different forms. It could be very overt. I'm going to terminate you because you complained of harassment. Very overt. A salary reduction, a demotion. How about giving someone a negative performance review right after they file a complaint of discrimination? Okay, those are obvious, should be no question. There's more subtle forms, however, of retaliation. Ignoring someone who filed a complaint. Some subtle change in behavior, like excluding the person from meetings or emails after they engage in protected activity. That could also be retaliation. And I had a case recently where an employee complained about a manager. And as a result of the complaint, the manager disinvited that person from the morning coffee chats that she had in her office. And the chats were part of team building, but also they would discuss work for the day. And the person who complained was basically told, you're not invited for coffee anymore. Subtle, yeah, no one has a right to free coffee, but it occurred after the complaint was filed, and she was the only one excluded. And frankly, these meetings were important for team building and doing the job. These are very difficult situations. You might have an employee who complained of harassment or discrimination, and then that employee might have performance issues. And you, as a good leader, want to counsel that person for the performance issues. Is it retaliation because they just filed a complaint? Or are you being a good leader by giving the person feedback? Sticky situations, best practice is make a partner with an expert in this. I think the best practice is to provide the feedback, but there's ways of doing it so you avoid a retaliation claim down the road. All right, next slide. All right, religious accommodation. And folks, I'm going at, I know, a slightly quick pace, but there's a lot of important information we want to get to today, all of which is important for you as leaders to know, to be as impactful and effective in your jobs. So quick pace. There's a duty to reasonably accommodate an employee's sincerely held religious beliefs or practices. And an accommodation is some change to a workplace policy or practice or to the work environment. You have to provide that unless to do so would cause what the law calls an undue hardship. What's an undue hardship? Very fact-specific analysis generally refers to an increase in cost, decrease in efficiency, or burden on other employees. For example, you might say, I can't grant an accommodation. If I do it for this person, everybody will ask for it. Well, that's a very speculative reason to deny it. And the law says if you want to prove undue hardship, you need evidence and specific facts. Towards that end, the law says that once a request for an accommodation is made, there should be an interactive dialogue with the employer and the employee to determine if the accommodation is reasonable and could be granted, or whether or not another accommodation might work for this employee. What's really important for you as leaders is don't dismiss a request outright. The law says you have to have this interactive dialogue to determine if the request is reasonable. For example, you might conclude, can't accommodate you, but we have another position that could accommodate your religious practice. Well, the law says you have to consider that transfer. Okay, some examples of an accommodation: a prayer break during work, early departure due to a Sabbath, time off for a religious holiday, perhaps some modification to your dress code or dress policy for someone's religious attire. These are all accommodations that may come up. You should spot them, and the interactive dialogue and the duty to accommodate kick in when these accommodation requests are granted. All right, next slide. All right, little activity. I've been talking for a while. We have two candidates, and they're applying for a box office position. And the requirements of the position are to work Tuesday from 12 p.m. to 8 a.m. In addition, the main job functions are managing box office operations, and that includes greeting patrons, answering questions at events, assisting the director in coordinating events. Okay? Two candidates. Candidate one worked for 10 years in a customer service position, greeting customers, handling customer inquiries, and has experience freelancing in event planning. However, she says to you during the interview, I can't work on Friday past 3 p.m. due to the Sabbath. Interview otherwise went very well. Customer two has no customer service experience or event planning work. However, recently graduated from college, warm smile, appears to have good communication skills, can meet the schedule requirements. Again, a good interview. You decide to hire candidate two. Is this discrimination? Jot down the answer, put it in the chat. Well, let's go through an analysis here. And this is the thought process this is what you should be thinking if you're in the situation of comparing these two applicants. And I'm starting to see some answers that come in. Good. I've got a yes. Well, is applicant one qualified for the position? Applicant one to me seems very qualified. In fact, I would say it's almost the ideal applicant. Set aside for a second the schedule restriction. On paper, candidate one seems almost ideal. Now, candidate two might meet the bare minimum qualifications, would certainly need training to get up to speed, but I think we would agree really not as qualified and maybe doesn't even meet the minimum qualifications, but not as qualified as one. Okay, now question two. Does the applicant's sincerely held beliefs conflict with a job responsibility or policy? Yes, there's a schedule requirement of working 12 to 8. Person needs to be off early on Friday for the Sabbath. That's a deeply held religious belief or practice that we would have to accommodate. Okay, let's assume applicant one then asked for an accommodation. I'd like to leave early on Friday. Does the requested accommodation pose an undue hardship? Is the next question you have to ask yourself. Well, what are some relevant considerations there? You need to understand the following. What's the job? What are the job requirements? What happens on Friday? Are there others who can fill in if this person isn't here? Perhaps Friday really isn't a very busy day for events or customer inquiries. Maybe it's a very busy day. How big is the organization? Are there other people who can fill in? Or this is a very small organization. The law says you don't have to hire others to do this shift if this person can't do it, by the way. Okay? So how big is the organization? Are there others who can do it? So you need to understand, those are facts you're going to need to have to get before you can really determine if the accommodation, if granted, would pose an undue hardship. So I think I saw some answers there that said this, on its face, this decision certainly suggests discrimination in the hiring process. And without knowing the answer to those questions, I would agree with those who said yes. Okay, next slide. Like with religion, the ADA and the Massachusetts equivalent law obligates employers to reasonably accommodate a person with a disability so the person can perform essential job functions. Again, it requires an interactive dialogue to determine is the requested accommodation reasonable. Under the law, you do not have to eliminate essential job functions, but it is a very fact-specific analysis, and as with the religious accommodations, the interactive dialogue is required. What are some examples? Well, we have them here. I need a flexible work schedule. Perhaps an employee says, I can't come in early due to the effects of my chemotherapy. I have chemotherapy Tuesday and I'm groggy or tired, I'm fatigued on Wednesday. Could I come in at 11 and not 9? That's a request for a schedule change due to a disability, in this case, cancer. Perhaps you have a hearing impaired employee who says, could you please provide me with a small handheld computer so I can communicate with coworkers? And this computer you could type information on it, you hand it to your coworker who types information and gives it back to you. So there's providing product or equipment to enable a hearing impaired employee, which is a disability, and enable that person to communicate with coworkers. Perhaps it's a request to provide a reserved parking space to someone who has mobility impairments, and the parking space is near the entrance and exit to the building. Perhaps there's a request for a larger screen on a computer for an employee with an eyesight impairment, or a special chair for somebody with back problems. Again, all examples of requested accommodations, but this brings up two important issues for you as leaders. Number one, do you have job descriptions? Because to determine what are the essential functions of the position, the EEOC, the MCAD, look at what does the job description say the essential functions are. And that's generally the guide to your analyzing whether or not you need the providing the accommodation would be a hardship, because the person must be able to perform essential functions. So make sure your job descriptions are up to date. Sometimes we create them and we put them in the closet and jobs change and we don't change the job descriptions. Also, very good to have a record of the accommodation granted or denied, and to keep the documentation. The accommodation might be temporary, the medical condition may change, and the accommodation needs to be updated. Have a record of what was granted. Finally, who should handle this interactive dialogue? Probably not the immediate manager, because you don't really want the manager of the person requesting the accommodation to know all these intimate personal details about someone's medical condition. Probably best practice is having a third party or benefits administrator in the organization handle this. But again, it might depend upon the nature of the accommodation, and how much medical information do you need to look at. As the employer, you do have the right to request information from a healthcare provider to determine whether or not the accommodation requested is reasonable. There are certain limitations on what you can ask. And again, working with an HR expert is good. Okay, next. When are you on notice of the need for an accommodation? Could be a very direct request. I need an accommodation. Could be stated indirectly. I need time off for treatment. I can't read my computer screen because of my eyesight. I have a back injury when I perform certain tasks. Again, the word accommodation isn't used here, but you're on notice of a medical condition that necessitates some workplace change. Okay, so an activity. Then we have our break coming up shortly. A phone contact agent has a degenerative eye disease causing blindness. Agent's been on the job for 5 years and needs an altered process and system enhancements to read prompts, training materials, input customer information. The result of this altered process or accommodation is that it would add to the length of time for each phone call with a customer and add $5,000 per year for these enhancements. You say, can't accommodate it, but I'll give you 6 weeks of severance to help you find a position elsewhere. Is that discrimination? Let's take about 15 seconds, think about it. Okay, next slide. Let's do the analysis, and here's what you should be thinking. Can the person perform essential functions with or without an accommodation? Well, I go back to the job description. What are the essential functions? If completing phone calls within a certain period of time is an essential function, maybe there's a objective metric that the company has. Perhaps the person can't do that function. Perhaps increasing the length of time of each call, would that impact customer service? So we need to know what are the guidelines for this position and length of time to complete a call. It may be essential, or maybe we don't care. Could be 10, 50, however long it takes to complete a call, it doesn't matter. So we need to know what is that an essential function? So let's assume that the person can perform the essential functions if you provide the accommodation. Well, is it an undue hardship? Well, let's look at this cost issue for a second. Number one, $5,000 a year. To a multi-billion-dollar company, $5,000 a year is not a lot. To a company with a $500,000 annual budget, that's a lot. So the answer is, it might be. By the way, if this person takes more time to answer calls, does that create calls going to other agents, creating a burden on other employees? All information you need to gather. And if you conclude we cannot provide this accommodation, it is a hardship, the question then becomes, is there another job this person can do in the organization where we don't have to provide this accommodation? And it could be a transfer to another position. If the answer is no, then you've checked all your bases and you're in good shape. But this is the analysis you need to go through. I believe we are at the break, but there was one really good question. If you need to make an accommodation, how do you best handle communicating that to other employees? How do you explain it to others? And some people say, gee, how come that person gets all these breaks or comes in late and I don't? And you want to avoid informing other employees about someone's medical condition. That's private, that's personal information you can't disclose. What you can say is, company policy requires us to accommodate this employee. The law requires us to make this workplace adjustment. Something like that. I know it sounds a little legalistic maybe, or it's not warm and fuzzy, but I think it's the right way to say it. We're required to make this adjustment for Jane, for Harry, we're required to do it. That's all you need to say. All right. So I think we have a 10-minute break. So let's resume at about 11:40. Okay, we're back. There was a question earlier about whether or not volunteers, whether or not these laws apply to volunteers. And again, and general rule is that the laws governing that regulate employer behavior does not apply to a volunteer. But let me give a few qualifications. Number one, it has to be a true volunteer. So if someone is getting some remuneration, some stipend, or there is some control over when and how the volunteer performs services, then we're blurring the lines between volunteer and employee. So is it a true volunteer or not is something we need to consider. Number two, it's certainly a best practice if a volunteer complains of harassment or discrimination to address it, because it might be by a employee of the company, of your organization. And if that's the case, you want to address it. In fact, I would argue you're on notice of harassment or discrimination by an organization employee, and you have to deal with it. Number three, just a good business practice, if you want to attract the best volunteers, is that you create the workplace culture in which they can optimally work and thrive. So let's not focus on are they protected by the laws, but what kind of organization do you want to have? I think we're going to address this question further in the Q&As that we hand out because there are some nuances under both state law and federal law to this. But I just wanted to give you the kind of the quick short answer because the question came up. All right, let's go to the next slide. And let's talk now about sexual harassment. The Massachusetts defines two types, as does federal law, two types of harassments, hostile work environment and quid pro quo. Next slide, please. The hostile work environment, we're talking about unwelcome and offensive conduct of a sexual nature. So sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. It's pervasive, it's severe, and has the effect of unreasonably interfering with an employee's work performance by creating an intimidating, hostile, humiliating, or sexually offensive work environment. And we have some examples of this. Let's go to the next slide. Oh boy, I'm sorry, there we go. Some examples of conduct that constitutes a hostile work environment. And by the way, there should be no dispute among us that this is stuff that's offensive, it's unwelcome, creates a hostile environment. We spend hours each day in the workplace. We don't want to have to deal with this. We don't want our employees to have to deal with this. Sexual innuendos or jokes. The dirty jokes, the locker room talk. Discussion of sexual activities. Let me tell you what I did last night, what I did with my partner, not appropriate for the workplace. Requests for sexual favors, asking a colleague for sexual favors. Offensive or provocative touching. General rule, touching is almost always a no-no. Now we're going to talk about the person who likes to hug in a second, but I had a case recently where an employee claimed that there was a hole in her shirt, under her arm, next to her breast, and a male coworker, in pointing out the hole in her shirt, touched her skin, went through the hole in the shirt, touched her skin, saying, "You have a hole here." Very sensitive area of the body, and she claimed she was offended by it and claimed harassment. And it would be that kind of touching that's well over the line. Sexually charged conversations. vulgar or crude emails or texts. I just have a case now where a supervisor sent to an employee triple X-rated pornographic texts and asked that the person engage in sexual acts with him and go out on a date, and sent these very crude texts. The texts were sent off company time, but on their personal cell phones. But guess what? It was 2 employees. It made its way back into the workplace. One was a supervisor. No. And sharing pictures of a sexual nature. Again, so examples of conduct that creates a hostile work environment. All right, next slide. The standard, is the behavior problematic? The law adopts a reasonable person standard. Would a reasonable person be offended? That's the legal standard. It's called an objective standard. Now, there's things we can all agree on is offensive, the stuff on the prior slide. But it's also a given that you don't know what will offend a coworker. What is that person's offense meter? When have you crossed the line? You don't know. So the best practice, and Sandra mentioned this in her section earlier, be professional at all times. Role model professional behavior. Avoid these types of banter of a sexual nature, jokes, touching, discussing sexual activities. Not professional, avoid it, and the organization should be okay. All right, next slide. Couple more examples, another activity. And these were all things that came up recently in my practice. Male employee says, "Do you need me to remove the lint from the back of your pants?" I would say that's a pretty subtle innuendo, saying, do you want me to touch your butt to remove some lint? Okay, the innuendo, the inference is very clear. Someone says, "I'm not putting my video camera on for the Zoom call." And someone on the call says, "Come on, let's see what you look like in the morning." Well, it might sound like a joke, but it could also be viewed as, gee, someone wants to view my physical appearance. What do I look like when I wake up? Creepy. It's got some sexual overtones. Avoid it. How about this? Patron greets an employee. Let's call it a supervisor, greets an employee with a kiss on the cheek and a hug. Well, the kiss on the cheek, I think, unless you really know the person well, the kiss on the cheek is a bit over the edge for me. But let's talk about the hugger. You know, there's colleagues of mine I've known for 10, 20 years. Whenever we see each other, we hug each other, and there's no issue. I had a complaint recently, though, where somebody said, you know, every time this manager comes into my workspace, he gives me a hug. I don't want to be hugged. I don't want him to hug me. I'm offended by the touching. So hugging might well be problematic, or it might not be, but need to be aware of it. Know your audience. If you're a hugger, if you get a complaint about someone, be aware that it could well be offensive, unwelcome conduct.
Hey, Mike.
Could well be taken care of by a short conversation with the hugger. Look, so-and-so doesn't want to be hugged. Please be careful about touching people, and you're done. This is, you know, not a warning situation probably, but certainly a conversation, because this behavior could be received as unwelcome. All right,
Mike, one question before we move on. So
Sure.
if it's a patron or a client that is hugging and kissing an employee, does the organization have an obligation to address that? And
The
how
answer
do you
is-
recommend you address it?
The answer is yes. Good question. The organization has an obligation to protect its employees from harassment and discrimination. Yes. You cannot ignore that. You have to create that harassment-free, safe workplace. It's a little challenging when it's a patron or some third party over whom you might have limited control, but you cannot ignore that. All right? All right, quid pro quo. This is where sexual advances, requests for sexual favors, and other verbal or physical conduct at which the submission or rejection thereof become the basis for an employment decision. So basically, it's this for that. Do you want the promotion? You will have to date me or sleep with me or have sex with me. Do you want to be hired? Let's go out on a date. And if the person rejects the request for sexual favors and doesn't get the job or the promotion, that's classic quid pro quo harassment. Now, one very interesting issue here is we encourage your organization to have some workplace relationship disclosure policy. And here's the issue. Romances occur in the workplace. It happens. But if the two people who are in an intimate physical relationship are in a reporting relationship, we would all agree that's a conflict of interest. Could the manager objectively evaluate and supervise a person with whom he or she is having a romance with? No. How is that viewed by other people? You have to have a relationship with the manager to get ahead. Is there favoritism going on among those people? Not a good workplace situation. So we would encourage you to have a policy that says if there's a direct or indirect reporting relationship, or the people who are in the relationship, one has the ability to influence the other's employment, that should be disclosed so the organization can take steps to address and eliminate both the conflict of interest and any perceptions of unfair treatment or favoritism. Very important. And by the way, a lot of workplace relationships, not a lot, some don't end well. We'd rather deal with that situation at the outset by taking appropriate steps rather than waiting for that to happen. Okay, Sandra mentioned this earlier, but you should be aware of liability. A manager, a leader, an executive with supervisory authority who discriminates or sexually harasses an employee, the company is strictly liable. You are responsible for the acts of your managers. And that's a tough one to defend. So very important that you as leaders know what you can, what behaviors you should avoid. It's your organization. And you, by the way, under the law, individuals are also liable for harassment by a manager. The standard's a bit different. If one coworker, an hourly employee, is committing harassment against another hourly employee, the company can avoid liability if you have a good policy, you've communicated the policy to everyone. We're going to talk about the elements of a policy in a second. And you have an effective complaint procedure and you handle the complaint professionally. It goes back to what Sandra said at the beginning, the role of the board and the executive director to communicate and make people aware of your policy, of your procedure, of your complaint procedure. And when people avail, if they don't avail of the procedure and there's some harassment by a coworker, we've got a defense, but we need to get that information out there. And I answered Tracy's question earlier. There is liability if a third party harasses one of your employees. You need to address that. Okay, next slide. Other types of harassment, there's racial harassment, could be racial or ethnic slurs in the workplace. I have a case where a Black employee found a picture of a noose on his workstation, and there were racial epithets written around his work area with racial slurs. We could have age harassment, comments like, "Oh, you're too old to perform the job. You know, here comes our old timer, can't keep up with the younger folks." Again, offensive, unwelcome conduct, instead of a sexual nature, of a race or age nature. Asking someone for a date. Well, asking someone for a date once, generally, not harassment. But if you've been told, "I'm not interested," and there's repeated requests for a date, then you're in the realm of sexual harassment. And again, these are just some more examples of harassing conduct that could come up in the workplace, in your organization. All right, some common excuses we hear. "I didn't intend to offend anyone." That's not an excuse for harassment. I said earlier, the legal standard, would a reasonable person be offended? Your state of mind is not, in the eyes of the law, what's going to control this. "Hey, everybody was doing it, so I just joined in." If everyone's doing it, it doesn't make it right. In fact, it makes it even worse, because it means there's something wrong here if a lot of people are engaging in it. "No one complained, so I thought my conduct was okay." Well, there are reasons why no one complains. Maybe they're afraid of retaliation. Maybe the harassment is by the senior leader. So just because no one complained doesn't mean it's right for you to participate in it. "Hey, we're all very friendly. We always joke and banter." Well, guess what? In those situations, you don't know when you've crossed a line and when someone's offense meter is going to go off. So act professional. Another common excuse. "Yeah, I might have done something that wasn't right with the coworker, but I was not on company time. I was off company premise. So what's the issue?" Well, guess what? As a leader, while no organization wants to control what its employees do on their personal non-work time, when those behaviors involve another employee, inevitably it spills into the workplace. So the fact that it was off premise and not on company time, if harassment occurred, if let's focus on the behavior, that's a problem, because these two people have to work in the workplace. You can think of company events, all the things that happen on company retreats. Same analysis occurs. And we've talked about the third-party vendor issue. All right, next slide. Very important slide. Again, one of the most important, well, these are all important, but this is critical. The knowledge that you as a leader, a person in a supervisory or managerial role, your knowledge is imputed to your organization. What you know, the organization knows, okay? So if you're on notice of potential harassment or discrimination, the organization knows it. Now, legally, when the organization knows it, there are certain things that must happen, which we're going to talk about next. But when are you as a leader on notice? Couple situations. You might observe or witness sexual harassment, okay? You didn't get a direct complaint, but you observe it or witness it. You're on notice. You receive a complaint from the person who's victimized or by a friend or other coworker. You're on notice. You learn about it in an exit interview. Someone says, "I was sexually harassed by so-and-so." Well, just because the victim is leaving the workplace does not mean that the problem ends. You're on notice. The harasser is still there. You get an anonymous letter. You're on notice. Now, the anonymity may go to how much weight we put on the letter, but you're on notice. Maybe a family member calls you saying, you're on notice. You hear about the conduct. Maybe it's hearsay. Oh, did you hear what so-and-so said to so-and-so? You're on notice. Here's the takeaway for you as leaders. Don't focus on how you get the information or how it's acquired. Focus on the knowledge you have. And if it constitutes potential harassment or discrimination, you and the organization are on notice. Now, there was a very good question that came up. Is it reasonable to assume that all the same guidelines apply to social media? Yes. Social media is a very complex. We could do a 2-hour training on social media. But if you have an employee posting on social media stuff that's harassing or discriminatory and you're made aware of it, you cannot ignore it. How we deal with it is a different issue, but you can't ignore it. Those are the situations to reach out to your HR or third-party expert. It may be speech that's protected under the National Labor Relations Act, or it may be speech, the social media post, that violates your harassment and discrimination policy. But you can't ignore it. So very good question. And I think in the FAQs, we'll put something in about that so you have a guide. Now, when else might you be on notice? I don't think my salary increase was fair. You don't hear the words discrimination here, but you see fair. Okay, perhaps it sounds to me like the person is saying, my increase perhaps was motivated by race, age, gender, some illegal factor. Juanita is not treated fairly by her manager, John, but she doesn't want to complain. Okay, not treated fairly. What does that mean? I've heard manager Paul say some really messed up stuff. What is messed up stuff? In all of these situations, you are on notice of potential harassment or discrimination, and you as a leader should drill down. So in number one, don't think my salary increase was fair. You should say, what do you mean by that? Help me understand it. Get more information. Then you could determine, is this a harassment discrimination issue or something else? John was not treated fairly by her manager. Do you know what happened? Juanita wasn't. What did Juanita tell you? How do you know this? Do you know why she doesn't want to complain? You're going to have to pick up Juanita and talk to her. I've heard Paul say some messed up stuff. What did he say? Did you see what Louise posted on her Facebook page? Okay. I think your follow-up question when you hear that is, what was it? What did you see? You might be on notice of harassment or discrimination. You don't know, but as a leader, you need to ask the follow-up question. Okay, next slide. Now, when you're on notice and when the company is on notice, there's a legal duty for the organization to investigate the complaint, take appropriate remedial action, punish the wrongdoer, and ensure there are no recurrences. And whether or not you inform the complainant of what action you're taking, again, that's something, we'll decide of how much you tell the person complaining, but you certainly want to provide some feedback there. But when on notice, this is the legal obligation. Investigate, remedial action, punish, ensure no recurrences. By the way, I've heard people say, I knew what was going on, but I didn't want to report it because the person doing the wrong misconduct is my friend, my neighbor, my manager. I've known the person for 10 years. We go to Little League together with our children. Well, your obligation as a leader is to the organization, not to your friend, your manager, your neighbor. And if you're on notice of this conduct, you have to report it to the right people so that the organization can investigate and take appropriate remedial action. Okay, next slide. Some practice tips. If you sense an uncomfortable situation, what can you do? Important thing is doing nothing is not an option. If you're witnessing some inappropriate conversation, break it up. We're getting off track. This isn't professional. Others may not feel comfortable. Let's take this offline. I think the point of this slide is that if you sense something is wrong, trust your instinct, intervene, always follow up. You may have to report it to the appropriate person in the organization and create some record of what occurred. But the worst situation you can be in is if you're witnessing inappropriate, uncomfortable, harassing conduct, and you let it go. You let it slide by. You ignore it. Because first of all, the message to the organization is management doesn't care about it. Leaders don't care. And in a lawsuit, the way that could be described is, oh, you, the leader, witnessed it and ignored it. And you don't want to be in that situation at all. So intervening, it's a good best practice for leaders. Okay, next step. How do you respond to a complaint? You listen carefully. Don't jump to conclusions. What's a common conclusion? Oh, you're complaining about so-and-so? He's a model employee. He would never do that. Never assume, never jump to conclusions. Take notes of what you're hearing. Probe for details. Someone says, she touched me. Where? She used vulgar language. What was it? We call this who, what, where, when, and how. Who witnessed it? When did it occur? What was done? And probe for details. Ideally, you should get a statement from the person who's giving you who's complaining. And it's always good to ask the complainant, how would you like me to resolve this? Now, the way the complainant wants it to be resolved will not dictate what the organization does, but it's good to know. The person may want it to stop. The person may want the bad actor fired. May not be able to fire the bad actor. We got to do our investigation, but it's good for you to know what does the complainant want as a result. Again, good to get a statement in writing, ask questions. By the way, don't do this meeting out in public. If someone comes to you, go to an office, close, you want to be in a private, safe place where you can have this conversation and others can't overhear it. Okay, next slide. Good. Some practice tips. This comes up a lot. Employee says, I'm going to tell you something, but I want you to keep it confidential. Can you do that? No, 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 cannot do. Why? When you know of harassment or discrimination, right, the organization knows and the duty to investigate and remediate kicks in. So you can't agree to keep it confidential. What you can say is, look, I'm here to support you, as is the organization. We have an obligation to investigate. We strive to maintain confidentiality to the maximum extent possible. We have a no retaliation policy. Others may be impacted by this. We want to get to the bottom of it because we want to have a fair, good, healthy workplace. So these are some things you can say, but you cannot promise to keep it confidential, but you want to get the information from the person. Okay, next slide. Some other practice tips. I think we're clear now that when you're on notice, you have a duty to report this so the right people can get involved and investigate and remediate. Please don't handle this on your own. A couple reasons there. One, you may not be a certified, trained investigator. Investigation is an art. Number two, we want to have a record of what was done. Because what if the person engages in more misconduct in the future? We need to have a record, something in the personnel file. If the conduct is so bad, we may have to terminate, and you may not be have the authority to terminate. So I've had a lot of executives who think they're doing the good deed, they get a complaint, they bring the complainant and the accused in a room when they do a kumbaya feel-good session. That is the worst course of action. Okay, so know who to report to, and we're going to talk about that before our time is up. But employee states that, employee states, I don't want you to take any action. I just want to make you aware of this. Well, you know, you might have to take appropriate action, but you could say to that person, you know, I'll keep you informed about the steps. Here's my card. You have my number. Call me if anything comes up, if there's any retaliation, but you can't promise not to take any action. What if someone says, I'm not going to give you a written statement? All right, they don't want to, we're not going to force it. I would review your notes with them. You can even have the person review and validate your notes, or at least go over your notes with them. Maybe have them sign your notes. They don't want to sign your notes. You can just make a note. I reviewed my notes with so-and-so, and nothing was added. Okay. And do you have an obligation to follow up, and how? We'll talk about the investigation in a second, but so important. When you finish the investigation, remember to go back to the person who complained. I've had cases where we never went back to the complainant, and the complainant thinks nothing was done. I complained and nothing was done. So the follow-up at the end of the investigation is so critical. All right, next slide. You receive a complaint. A couple preliminary considerations. You have to decide, do you have to separate the complainant and the accused? Sometimes organizations have a knee-jerk reaction. I'm going to send the complainant home for her own safety or his own safety. Well, that could be viewed as retaliation. We may send the accused, put the accused on a leave. Maybe we separate the two by changing their work times. But you have to consider, is separation necessary? And if so, how? Good time to consult with your expert so you don't fall into a retaliation trap. You can inform the complainant that we'll keep this as confidential as possible, but you have to share information with those who have a business need to know. Look, to do a proper investigation, you're going to have to talk to witnesses and the accused. So you have to share some details. You can stress to the complainant that we have a no retaliation policy. And this is an important thing to say. If you experience any retaliation, please come to me immediately, and I will address it, because that's against company policy. You should ask the complainant to keep it confidential, because that protects the integrity of the investigation. You don't want this out in the whole workplace. You don't want witnesses to be influenced by what they hear. So ask the complainant to keep it confidential, and give a time, approximate time you're going to get back to the complainant. Okay, those are some best practices when you get the complaint. Now, there's always a question of how broad, what's the scope of the review? Well, is it harassment or discrimination? The answer is yes. Obviously, we're going to do a thorough investigation. Sometimes people throw out the harassment word. I'm being harassed by my boss. And what they really mean is my boss is giving me coaching and feedback and I don't agree with it. Now, that's not illegal. That's a role of management. Maybe the manager is not doing it effectively, but it's not illegal. So I think it's important to follow up and ask questions. What do you mean harassment or discrimination? Explain it to me. What's going on? How serious is the complaint? What's the nature of the concern? That also will determine the scope or review the scope of the investigation. Let's say the complainant says, you know, I'm offended because so-and-so didn't use my preferred pronoun. Well, that could be gender identity discrimination, harassment. It could be a mistake, an innocent error. So if that's the complaint, you would say, can you give me some details? What happened? What was the context in which it came up? Getting these details helps you determine how broad and how deep and how detailed your investigation is. Sometimes you have to uncover every stone, and sometimes you don't have to go that broadly. But it's governed by the details you get when you get the complaint. All right, next slide. Investigation. What does the law require? It's got to be thorough. It's got to be prompt and timely. It's got to be unbiased and objective. And the investigator should be trained in conducting investigations. Again, this should not be done by a leader, a manager who doesn't have the training. These are complex issues. To do them right requires a certified, trained investigator. By the way, what is your defense if a charge is filed? Your defense is, we did a prompt, thorough investigation and took appropriate action. The investigation is your first line of defense should there be a charge or a lawsuit. So you want it to be good, not just to get rid of discrimination in the workplace and send the right message to other employees or volunteers that we handle misconduct, but this is your first line of defense. And it's going to involve taking statements, identifying witnesses and interviewing them. Maybe there's documentary evidence like inappropriate texts. I had a case where there was offensive handwritten material put on someone's windshield wiper. That was a piece of evidence. And it's very important that we have a file of the investigation, and the file is kept in a certain place. And one of the issues you need to be aware of is that you have a record-keeping procedure for keeping investigative files. Okay, next slide.
Mike, there's one question in the chat. If you could, you might have to ask a clarifying question, but if you could take a look at it and see if you could address it.
Sure. You may ask the complainant not to share. However, many times people have discussed it among themselves before reporting it. Then what? Look, if people discussed it among themselves, you can't avoid that. Unavoidable. But there are steps you may want to take to limit the disruption. So first of all, those who have discussed it among themselves, they may all be witnesses, and you're going to probably want to talk to them. But you could also say to them that this is a personal, sensitive matter. Please keep it confidential. Sometimes, so bottom line is you can't prevent that. But once the investigation starts, you can tell people to please keep this confidential. In fact, some organizations say that keeping it confidential is a condition of employment. And I've seen organizations punish or terminate a complaining party or a witness who didn't keep it confidential. Now, be aware, you could get a retaliation claim for that. But the important thing is to tell people who participate in the investigation or who complain or against whom the complaint is made, that you must keep this confidential. That's the important thing. Small organization doesn't always have a trained investigator. So who should investigate? Good question. You know, I would say you can reach out to a third-party expert. There are third parties who handle investigations. There are HR organizations that do this. You may decide to train someone. I don't think that's the best course of action, though. I think it's good if you're a small organization to have someone on the outside do it, especially if you're going to be, think about this, if you have to interview people who might be witnesses or are the bad actors, what if those people are above you in the hierarchy of the organization? It's tough to interview an accused who is at a higher title than you. So these are situations when bringing in a third party may be the best way to go. And that would promote fairness and objectivity. I hope that answered it. Okay, what are some remedial measures? Well, verbal counseling. If you determine, if we substantiate that there was a violation of company policy, counseling, maybe a last chance agreement, a final warning, perhaps an unpaid suspension, or worst case, a termination. It depends on what the investigation uncovered and how serious the alleged conduct is and what you could corroborate. Always a good thing to consider is some kind of management coaching. Perhaps the accused is not going to be terminated, but will stay in the workplace, but needs some one-on-one coaching to make sure that person knows what is prohibited going forward. Perhaps the entire organization needs some training like we're doing to get the word out. So always a good thing to keep in your, I call it the quiver of arrows in terms of what are effective remedial measures. Remember, the goal is what will put a stop to future recurrences. It may be simple counseling. It may be some broader training. Okay, next slide. You get a legal complaint or an agency charge from the EEOC, the MCAD. Certainly want to find out what's the nature of the charge, read the face of it. There's different boxes. Remember, we said earlier that a charge could have different claims, and sometimes there's claims on race, sex, pregnancy, retaliation. So what's the nature of the charge? There's usually a description of the conduct constituting discrimination. Probably want to involve your organization's legal counsel. This is a legal proceeding, and there's legal liability here. You may decide you want to settle this and use mediation as a vehicle to settle it, but it's something that should be considered. Maybe you've got a problem, the facts are bad, or other compelling reasons to settle. I think the data is that the majority of charges are dismissed by the EEOC. It's a very high percent, but sometimes there's merit to a charge, and the best thing for the organization is to settle it. The MCAD, the EEOC do provide free mediation services. But again, it's a decision you want to make after you've analyzed the charge and the potential exposure. If you decide you don't want to settle, you're going to have to submit a written response. Your position statement is like a story of what occurred and why you're not liable. And usually it has supporting documentation. And sometimes you have a person who filed the charge who's a current employee. It makes these a little more challenging, but you need to make sure you avoid retaliation against the current employee or anyone else involved in the complaint. Okay, next slide. What are the best preventative measures for an organization? Act professional always. Simple rule. Have the annual code of conduct reminder distributed through the organization. Stress it, talk about it, reiterate the company's values, culture, and commitment to anti-discrimination and anti-harassment. You want to have a detailed anti-discrimination policy that has a robust reporting procedure. You want to have trained investigators. And you want to make sure that new hires, volunteers, and vendors are made aware of your organization's commitment to these principles. Okay? Finally, next slide. What is an effective policy? Well, the Massachusetts Commission Against Discrimination actually has a model policy on their website. And it says it should state that harassment and discrimination is illegal, won't be tolerated. It asks that the organization define sexual harassment and provide examples. And we gave you a few examples here. And some of those are right from the MCAD sample policy, examples of sexually harassing conduct. Explain how employees can report harassment. And this is critical. There's a focus on providing avenues, multiple avenues, not just one, but multiple avenues for employees to file complaints. If the harassment is by the employee's manager, he or she is not going to want to complain to the manager. Perhaps it's by the manager's manager. So the law encourages multiple avenues of complaints. It could be any manager, could be the executive director, it could be the board. Some companies have anonymous complaints, which I would encourage you to consider. You can hire a third party and they have an anonymous hotline. So a person who's very afraid of retaliation could file a complaint anonymously. The goal in the eyes of the law is to get the complaint bubbled up, and that should be your goal. Because once the behaviors are bubbled up, you can deal with it and put an end to it. So the goal is not to cover up, but to bubble up. The goal is to get the conduct in front of you so you can address it. Policy should say that you'll protect confidentiality, that there'll be no retaliation for reporting or participating in the investigation, and you could describe your investigation process and remedial action taken, including response. Okay, so I see we're running low on time. In closing, when in doubt, I think the message we're sending is make a partner. This stuff is not easy. The law is complicated. Work with others in the organization or an expert. Encourage dialogue through an open door process. You want to hear about what's going on so you could address problems and create a better workplace culture. Golden rule, showcase the behavior you expect from others. Act professional at all times. And the annual review and sign off of organizational policies. You might have annual training, reminder training, refresher training. That's another way to reiterate your organization's commitment to no harassment and no discrimination, and to further a good workplace culture. So 12:30, we are right on time. Thank you, everyone. Once you'll receive an email from Tracy. Once you get that link to confirm your attendance, you'll get a copy of the presentation. You can ask additional questions and provide any feedback. So thank you all.